Good morning. Welcome to another Zoom oral argument session of the 5th District Court of Appeal. It is Thursday, February 23, 2013. I am Chief Judge Brian Lambert. I'll be presiding over the two oral arguments we have this morning. On my panel with me, you can see on the various boxes on the screen are Judge Rand Wallace and Judge Adrian Saub, one of our new members to the court as of January 1. We welcome. Again, we have two cases. Both sides will have 20 minutes to argue. The appellant, I will reserve 5 minutes, or 5 minutes will be reserved for rebuttal. You see the clock, it's in my upper left-hand corner. The marshal will be keeping time on that. When you get into your rebuttal time, appellant, you'll see the yellow light go on. You can continue on using as much of that time as you want. You do not get more than an aggregate of 20 minutes, so use your time as you deem fit. Remember, we are on YouTube right now, so people theoretically are watching us or can watch us later if they deem to do that. So keep that in mind when you argue to the court. Also, if you have any electronic devices, phones, etc., please turn those off or put them in the mute position so that they do not go off and either distract you or your opposing counsel or the court. All right, our first case on the docket this morning is case number 23-14. It's a case that was transferred from the 1st District Court of Appeal when we had our realignment effective January 1 of this year. It is Rico Javon Graham versus State of Florida. Ms. Reese, if you're ready, you can proceed.
Good morning, Your Honor. Thank you.
Good morning.
May it please the court, counsel. My name is Rachel Reese, and I represent the appellant in this matter, Rico Graham. There were 3 specific issues that were raised by Mr. Graham in his pleadings, but I would like to focus the majority of the argument today on the issue that was raised concerning the court's error in denying Mr. Graham's judgment of acquittal motion after the state failed to present evidence sufficient to prove that he was in possession of cocaine, heroin, and controlled substance paraphernalia. One thing that's important is that Mr. Graham originally went to trial on 5 specific counts. 2 of them involved trafficking amounts of cocaine and fentanyl, and then the other 3 were possession. Now, the jury ultimately found Mr. Graham guilty of 2 counts of possession. One of those was a lesser included offense of the trafficking of cocaine, and the other one was a possession of heroin, and then a possession of a controlled substance paraphernalia. The other 2 counts, which was trafficking in fentanyl and possession of marijuana, he was found not guilty of. And that's important for this court's consideration because of where all these items were ultimately found, and that's important to the arguments that were made below. The trial court erred in this matter because the state failed to prove beyond a reasonable doubt that Mr. Graham, number 1, had knowledge that the contraband was in his presence, and number 2, that he had the ability to exercise dominion and control over those substances. I think the most significant and the main issue at trial, which the court ultimately found in favor of the state, was that Mr. Graham was in exclusive possession of these premises where the items were found, and as a result, the state was not required to offer independent proof of the fact that Mr. Graham had control and knowledge over these items. There was an inference because of that exclusivity. And the argument that was raised by Mr. Graham, and I would like this court should find as well, is that the premises that he was found on and the items were found on as well was not exclusively possessed by himself alone, requiring the state to offer independent proof of those 2 main elements in order to find the possession for him. Now, the facts that the court relied upon and what's been long held in Florida is that an individual does not have exclusive possession over premises if another individual has equal access to the place where the contraband is found. So in this situation, it was a residence. It was kind of like a triplex. There was 3 individual homes. This was the center home, and all the items were found within the kitchen or a bag in it was described as a back bedroom, but it was located off of the kitchen area. And the importance of this is that
Mrs. Reese, I think the facts of the case, could you clarify for me? We had testimony from the officer that was surveilling the premises immediately before the search took place, that the testimony from the officer was there was a person, a man, and I believe it was a white t-shirt that fit the description of the defendant that was in the kitchen area immediately before the warrant was executed. And that ultimately was where a lot of the evidence was, at least the evidence that was admitted into evidence at the trial, was located. Is that correct?
I think that looking at the evidence in the light most favorable to the state, that is correct, Judge.
Okay,
And that
so
was,
wouldn't that be a strong evidence in support of not only knowledge, but exclusive possession, at least in the immediate area where Mr. Graham was immediately prior to the warrant being executed?
so 2 points. Now, the first point is that obviously, and again, we have to look at this claim in the light most favorable to the state. So that's something that we are aware of. However, there was obviously other evidence that was in dispute as to the timing of the video. And obviously the question of whether or not the detective that was doing the surveillance before the search warrant was executed, whether he was credibly testifying that this all happened in the course of a consistent consecutive time period, or if Mr. Graham had actually been at the residence earlier that day because of the timestamp on the metadata of the actual video. So I know that that was something that was in dispute. In terms of him being actually physically there immediately before and him being on that video, I would submit to the court that he also, in that exact moment, he was not the only person that was inside the residence. I believe that the evidence reflected that there had been someone else that came to visit with him. So I think that, if anything, that evidence actually shows that law enforcement waited until he was in exclusive possession or by himself at the residence and before they executed the search warrant. They could have executed the search warrant while there was someone else present, but that would have messed up their plan. So I think that, if anything, I think that the video evidence, light most favorable to the state, it happened right before the search warrant, actually helps Mr. Graham's case, because it shows that there was somebody else with just as equal access to the kitchen, which was right off of the front door, as Mr. Graham. So I, again, would submit that that evidence does not conclusively show that he was in, if anything, it shows that he was in joint possession, not exclusive possession. And that leads us to, obviously, the other evidence that was offered as to why this was not exclusive. This was a house that was being renovated. As proof from the photographs, the videos, there was multiple items. The entire house was something that was being redone. There was a lockbox on the outside door with a code that was testified to at trial. There was multiple people that had access. Obviously, even just in the 2 days, I believe it was 2 or 3 days prior to when the search warrant was actually executed, law enforcement had only done surveillance on a couple of days. But even on those 2 days, they saw individuals coming and leaving. Of course, their argument was that the inference was that it was individuals who could be involved with these drug sales. But as they revealed, they never did any follow-up investigation to actually confirm that. So again, the inference could also be that they were contractors, electricians, things of that nature for the renovations. And there was also testimony that there was employees that were given the code, family members that were given the code. This was something that was accessible to more than just Mr. Graham, which is why this was not just an exclusive possession case. Now, there was also items that were found inside the residence. I believe there were some Target bags towards the back bedroom. There was evidence that someone might have been residing there. And then Mr. Graham, of course, testified that his cousin had been given access in addition to other family members. So again, we are looking at this from the perspective of a house under renovation, accessed by multiple people. Mr. Graham's not controlling when or how they have access. As long as you have that code and you can access that lockbox. I believe that the detective even acknowledged that one time he sold his house and also had a lockbox. Anybody who has that code can come and go as they please, and there's really no control over who comes and when they leave. And because there was no other surveillance besides that, our position is that obviously the state, even looking at it in light most favorable to them, it still supports a finding of joint possession and not exclusive. Now, based on that, I believe that the court relied on a couple of facts that I think are important to at least note before moving on from the exclusive possession argument, is that the court found that because he was alone, obviously when they searched the premises, which I believe, Your Honor, that was kind of the point that you were leading to, that infers or its support for exclusive possession. And our position is that there's been cases where that's just not the case. And again, the fact that there was someone else immediately prior to this with Mr. Graham just further supports that that's not sufficient. The other fact that the court relied upon was that the fact that he owned the business that owned the premises, and that I believe the electricity was in his name. And there have been several other cases, and I believe one of them that was cited in the brief was Mitchell versus State, which is from the 4th District in 2007. But in that case, the court found that even though the defendant had an electric bill in his name, because there was proof that others resided there and had access to it on occasion, I believe he had a roommate, and there were several other individuals that would commonly stay and leave whenever they wanted to, which is very similar to this situation. It was a joint possession situation, and as a result, the state was required to prove and offer independent proof of those two additional elements of the knowledge and the control. Now, our position is that the state did not present any independent proof, and the trial court did make an alternative finding and an argument as to why the court felt that they had satisfied that burden. But our position is that that is absolutely not the case. The court relied on the fact that Mr. Graham was found guilty of possessing the scale that was found in the kitchen in plain view as proof that the jury could have inferred that he was guilty of possessing the drugs that were found in the kitchen drawer and then the black bag that was ultimately found in that back bedroom. However, there's case law that says just because there is evidence of drugs in one area of the house does not mean that the jury can reasonably infer, or that it is evidence supporting that he knew that there was drugs or controlled substances in other parts of the house. There was a case out of the 1st District in 2004, Hill versus State, where the state presented argument and evidence that the defendant was sleeping in a bedroom. A search was conducted. A small amount of cocaine was found in plain view, and then there was 2 large amounts that were found in hidden dressers. And this case is really important, and I think it's comparable to our case because the court in that case said the cocaine found in plain view, that could have been linked to this defendant. However, there was nothing else additional that linked him to the hidden amounts. And in that case, there was a confidential informant that even told law enforcement that is his bedroom, but they could not say that that was going to be in the drawers. And Mr. Hill even said in that case, the defendant made a statement when he was arrested saying they found it. And the court even said, even with that statement alone, the court said that was not enough independent proof to prove the knowledge or control. And in our situation, Mr. Graham never made any statements alluding to his knowledge or control over any of the items that were found. There was another case that was cited in the pleadings, which is Clark versus State. And in that case, Clark was charged with possessing cocaine in a house that he shared with another female. And the cocaine, ironically, was found in a kitchen drawer, which is exactly what we have in our case. And it's important and it's distinguishable from our case for a couple of reasons. Number one, the court found in Clark that obviously the kitchen drawer is a jointly accessible place. It's not like it's in a bedroom that is solely occupied by one person. It is in a kitchen in the public, but it's also closed off. But in that situation, there was items belonging to both a male and a female in that drawer. So the court found that there was joint access. It wasn't just, again, exclusively for one of them. But they also found there was no fingerprints on the container of cocaine. So that was towards the defendant's favor. In that situation, the defendant did make statements before the search to an informant that he was in possession of cocaine in the house. The court still found that even with that statement, with nothing else, that the court could not decide that it would not be able to find that those statements were proof of that specific cocaine that was found on that specific day. And again, I think that's important because there is nothing in this case, even the inference that the state implied through the other witnesses in the days leading up of these sales or whatever they argued was happening. These were not proof that Mr. Graham had the knowledge or control on the day of the actual arrest and then the search. Again, all of this keep in mind with the fact that there is a burglar door on the front of this house that is open at almost all times and it's visible to the public. Now, again, starting with the cocaine that was found in the kitchen drawer in this situation, which is ironic considering the fact that the 2 counts Mr. Graham was found not guilty of were also found in a kitchen drawer on the other side of the sink. So the cocaine that was found on the left side, he was found guilty of, and the cocaine and the drugs on the right side, he was found not guilty of. Now, there was no forensic evidence, fingerprints, or DNA linking him, obviously, to the cocaine that he was found guilty of. He never made any statements before, during, or after his arrest that would allude to his knowledge or his control. It was not in plain view. It was obviously hidden in a drawer at the time of his arrest. And the only evidence that I believe was offered at all towards his knowledge or control is the assumption that because there was a scale on the counter in plain view that had some sort of substance, that white powdery substance, that the jury could then infer that he had knowledge. However, that was obviously not enough to infer that drugs were found in any other place of the house. Now, the heroin that was found in the black bag is a little bit different because that's obviously in a different room. It's a considerable distance away in comparison to the cocaine in the drawer. That was hidden from plain view, and without more, the knowledge of what was inside that bag cannot be inferred. There was testimony from officers that Mr. Graham, when he was apprehended, he was laying down on his stomach and his hands were outstretched and they were in close proximity. But close proximity, again, is not enough to infer or assume that he knew what was inside. There was no other items that were found within the bag that would identify Mr. Graham as being an owner. And again, with an inference, if there was, that he knew what was inside. He never made any statements acknowledging it. There was never any forensics linking him to that. And I think what's important also to note is that he had how much time he had between when they announced that they were going to break down the door and then when they actually did. Mr. Graham still, if this was so close and he knew it was inside, I believe one of the officers even said, why wouldn't he have thrown the bag? He could have gotten rid of the evidence. There was a bathroom that was close by. There was a window. He could have thrown it across the room. And again, with all of the other items that were within the house, it would have been something that he could have very easily have put away from his person. Now, in Evans versus State, which was from 2010, the court found that there was a duffel bag inside of a bedroom, which is very similar to the situation. We have a small bag in a bedroom. And in that situation, they had been told that the room belonged to the defendant, but nobody could say for sure that the duffel bag belonged to the defendant. There was even a passport in the same duffel bag that they found cocaine, but the court ultimately found that because they could not timestamp when the passport was put in the bag or when the cocaine was put in the bag, they found that the passport could have just as easily have been slipped in there after the cocaine was, and that inference was not enough to support reasonable doubt that the defendant in that situation, Evans, knew that there was cocaine in that duffel bag or that he had the control to control it. Now, again, in our case, we have not even as much evidence as that. We have a black bag. Not a single witness testified that they saw Mr. Graham walk into this house with that bag. Again, that means that the black bag was already there when he entered that house that day, arguably from someone else because of all the other individuals that were coming and going on a everyday basis. I think it's also important, again, the fact that this was surveilled, the house was surveilled 3 times prior to the execution of the search warrant. And immediately before, there was just multiple people that could have been stopped and spoken with, and law enforcement did nothing. And again, those individuals all could have offered this independent proof that we need and we lack to support these 2 other issues: the knowledge of a controlled substance being there and the control over those individual pieces of controlled substance. The state in this case failed to do that. They did not offer any other evidence, no statements, any other thing that ties Mr. Graham to the items that were found in the black bag, the items that were found in the kitchen drawer, and even the items that were in plain view, that no reasonable jury would have been able to find Mr. Graham guilty of these 3 offenses. And so we would ask your honors to look at the court's decision below and find that the court erred by denying Mr. Graham's judgment of acquittal. Thank you.
All right, counsel, thank you. You have 3:30 and 3:29 in rebuttal. All right, Mr. Lawton, whenever you're ready, you may proceed, sir.
Thank you, Your Honor. Your Honor's counsel, may it please the court. Zach Lawton for the state of Florida. On March 28th and April 2nd, 2019, an officer observed as Rico Graham entered an apartment he owned and was renovating. As the officer watched, individuals came to the house. Graham let them in. They went into the kitchen, and then the individuals left. None of them appeared to be doing renovations. A few minutes after the April 2nd surveillance, armed with a search warrant, officers went to the apartment to conduct a search. Graham, who was standing outside at the time, saw the officers, entered the apartment, and locked the door. When officers knocked, Graham did not respond. The officers entered and found Graham in the back room. One officer saw that Graham's hand was in a bag that was later found to contain heroin. Graham was carrying $2,900 in cash, and several items of drug paraphernalia were in plain sight in the kitchen. Near the paraphernalia in the kitchen was a drawer containing bags of cocaine. Graham was the only one there. Now, Graham argues now that he did not have exclusive possession of the apartment because a lockbox on the door allowed construction workers who had a code to enter the apartment. He also argues that the state failed to prove that he had knowledge of the heroin and the cocaine. Now, the trial court properly denied Graham's motion for judgment of acquittal for two reasons. First, Graham exclusively possessed the apartment. And second, if Graham jointly possessed the apartment with everyone who had a code to the lockbox, the state presented evidence from which a jury could determine that Graham actually possessed the heroin and constructively possessed the cocaine. Now, constructive possession does not require that Graham was the only person with access to the apartment. Otherwise, a person who kept their door unlocked or gave a key to somebody would never be considered to have exclusive possession of the property. Graham owned the apartment, the utilities were in his name, and he controlled who entered the apartment. So those construction workers, and of course, we don't have any actual evidence that any of them came and went. We don't know that the key in the lockbox actually worked in the apartment, but assuming they could, if those construction workers were to come in and sleep at night without permission, throw a party in the residence, they would not be allowed to do that, and they could be trespassed for that. Graham certainly was controlling who came and entered. And the existence of a key certainly does not mean that those people had joint possession of the residence. And for example, if this is coming straight out of the Stevens case, that a landlord having a key to a residence that people are living in, or a housekeeper, a neighbor, a family member, just because somebody else has a key doesn't mean they have joint possession of that residence. Now, in the initial brief, a few things that I would note that are important. One is that the facts in the initial brief are all written making inferences in favor of the appellant. And of course, we have to see the facts in the light of the state. Now, the second thing I want to point out about the initial brief is that it uses the pre-Bush standard. Of course, we know that now we just need competent substantial evidence. And the cases cited in the initial brief are all coming before that Bush case, with the exception of Roberts. And these are circumstantial evidence cases. None of these cases involve someone saying, I have knowledge of this. And so it's using circumstantial evidence to determine knowledge. And the circumstantial evidence standard, of course, has changed. And the Roberts case is the only case in the initial brief that comes after Bush. And the Roberts case was a case involving a vehicle with more than one passenger, so it's easily distinguishable. And also, I'd note that the initial brief, the cases cited in the initial brief, there are a lot of cases, but they almost all involve more than one person either being present at the time or living there, and we don't have that here. If Graham's trying to argue that his cousin had joint possession because there were some things in the apartment, the record made it clear that the sleeping bag and the pillows and everything that were in the room for the cousin to use had not even been opened yet. The intent was for the cousin to start staying there, but he wasn't staying there yet. Also, the reply brief argues that basically none of the individual items that are argued in the answer brief were enough to show knowledge. And of course, there is case law in some of those things, but I'd point this court to Green v. State, which is a 5th DCA case, 625 Southern 2nd, 1293. And then what Green looked at was there were, in Green, there were 3 different things that were used to show knowledge. And they said, well, even if any of these aren't individually enough to show knowledge, the totality of the circumstances is what you look at. And the totality of the circumstances here, we have consciousness of guilt because he enters the apartment and locks the door and doesn't answer. We have quite a lot of paraphernalia in the kitchen. We have a scale with residue. We have bags with residue. We have a pill bottle with residue. And those are all within arm's reach of the drawer that contains the cocaine. And in the trash can, you have the wrapping that is, we call it kilo wrapping, but which wasn't brought into trial, but it's wrapping that was consistent with narcotics. In addition to this, Graham was seen in the kitchen near that drawer shortly before this happened. And the person who came in for a minute was let in by Graham, didn't use the lockbox, was let in by Graham, came in, was there for a minute or two, and then left. Didn't have any kind of construction equipment, didn't appear to be doing renovations, was simply what seems most likely to the state is that that person was in for a drug buy. And additionally, there was testimony that Graham was in the kitchen at the time. So the idea that that person could have been coming in and having access to that drawer seems unreasonable. And of course, Graham had $2,900 in cash, which the Brown case out of the 5th DCA, which was cited in the record, not in the briefs, 766 Southern 2nd 485. In Brown, it was this court held that it was proper to consider an amount of cash that a person had in a possession case. And if there are no other questions, I would, and I do want to point out that it's on the heroin, it's very important to note that his hand was actually seen in the bag. I know the evidence was disputed, but viewed in the light most favorable to the state, we do have a witness who saw Graham holding the bag and his hand in the bag of heroin, and that's actual possession. There's at that point, the jury certainly has the ability to infer knowledge. And if there are no questions, I would ask this court to affirm.
Okay, thank you, counsel. All right, Ms. Reese, you have 329 in rebuttal. Whenever you're ready, ma'am.
Thank you, Your Honor. Just a couple of points that I wanted to follow up with based on the Attorney General's response. First and foremost, I believe that the counsel mentioned the consciousness of guilt of Mr. Graham when he went inside the residence. And I think that's something that is actually important for this court to consider. Number one, there were several officers that testified about what they saw. I believe one officer said that he didn't even see Mr. Graham when he went inside the residence, just again, alluding to the fact that Mr. Graham went inside before law enforcement actually got there. And there is case law that specifically says, and it's not about actually going inside, but it's kind of in comparison to nervousness. That is not enough. Him simply going inside when he sees law enforcement is not enough in and of itself to prove that there's an inference that he knew something inside was illegal. Again, if that was the inference, then the inference would also be that Mr. Graham, instead of lying on the ground and extending his arms to almost touch this bag that ultimately had drugs that he was convicted of, if that was the inference, then the inference would have been that he also would have thrown that bag and disposed of it. So I would submit that that does not actually weigh in favor of the state. If anything, it weighs in favor of Mr. Graham. The second issue that I just wanted to address briefly was the standard of review that was obviously cited in the initial brief. And again, this is not a circumstance. The standard of review has changed, and now under Bush, obviously it is different. However, I think what is important is in Bush, they specifically say that although it's no longer the hypothesis of innocence, the concern is still that a rational trier of fact has to find the existence of all the elements beyond a reasonable doubt. So it is not the same standard as it was before, but that is still a very high burden of proof. And in this situation, stacking of inferences is not sufficient to satisfy that. So again, regardless of what the new standard is and the fact that this is a circumstantial evidence case, even with the new standard, the evidence is not sufficient to overcome that burden, which is why the trial court should have granted Mr. Graham's motion. I would ask that your honors seriously and with great weight look back at the testimony of the main detective who was responsible for the surveillance and then ultimately was, I believe, the lead investigator, which is what the Attorney General is relying upon as the person who saw the hand inside the bag. I would submit that a review of that testimony in and of itself is inconsistent, and ultimately his testimony alone weighs more in favor that he did not see Mr. Graham's hand physically inside the bag, that the bag was unzipped in his close proximity. And I believe that is on page 462 of the record through 464. He goes back and forth, but ultimately says that he can say that Mr. Graham's hand was in close proximity to the bag. Was it quick? Was the bag kicked? He cannot say, but ultimately that it was not inside. So I would ask that your honors carefully review that, because I think that is significant to the entire argument. as to why Mr. Graham is absolutely entitled to relief. And I would ask that your honors find that the trial court erred and vacate Mr. Graham's judgment and sentence accordingly. Thank you.
Okay, thank you, counsel. All right, we will stand adjourned till our 10 o'clock Zoom. Have a good day.